The Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oh yay, all persons having formal business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
Mr. Beers, when you're ready.
May it please the court. My name is Paul Beers. I'm a lawyer in private practice in Roanoke, Virginia. I want to thank the court for appointing me to represent Omar Banks in this interesting appeal. I'd like to, if it please the court, focus exclusively in my oral argument on the constructive amendment issue that's addressed in my reply brief. And specifically, that concerns counts 10 and 11. Count 10 being a charge of possession with intent to distribute a certain amount of methamphetamine, and count 11 being a section 924C count that's predicated on that. The Judge Jones, at the request of the government, instructed the jury that they could find Mr. Banks guilty of count 10 if he either possessed with intent to distribute a certain amount of methamphetamine, or if they found that he actually distributed that methamphetamine knowingly, intentionally. The problem with that is under our precedent, particularly United States versus Randall from 1999, in that case, it was established that those are distinct offenses. They are distinct elements. They may be similar. They may arise from the same. They do arise from
a lot of water has gone over the dam since then. Supreme Court in Mathis would say that's one offense, right?
I do not think so, Your Honor. I'm not aware of that. I think it continues to be two offenses.
Well, if you're right, it'd be four offenses because it says manufacture, possess with intent to distribute, and one other aspect. But those would all be means to committing the offense. I don't think Mathis would allow that to be four offenses.
Since, Your Honor, thank you for the question, Judge Niemeyer. Since they haven't made that argument in their brief, the government hasn't, they haven't cited Mathis.
No, but we're talking about a constructive amendment. And the fact of the matter is, if you are charged with possession with intent to distribute, and the government proves an actual transaction of distributing, it has proved its case. Because distributing, you have to possess it with intent to distribute. And so, and Randall was just the flip. And factually, Randall was that charged with distribution, and yet if the evidence shows you only possessed it with intent to distribute, you didn't distribute it. That's assuming there are two offenses. But even if it's two offenses, the flip side is that if you're charged with possession, then if the government shows that you distributed, they have proved possession with intent to distribute. And that's exactly what the court said in 17 in its instruction. It said, advise the jury that he was charged with knowingly, intentionally possessed with intent to distribute 50 grams. So it correctly instructed him. And then it said, for you to find him guilty of that offense, the government must prove each of the following beyond a reasonable doubt. So now the court's focusing on a proof. It's not an element. And the court says that he either possessed with intent to distribute or he distributed, which is an accurate statement. And then the jury is asked to find, did he possess it with intent to distribute, not distributing? And the jury found yes on the charge. There was no expansion of the offenses. There was no additional proof. There was no a new offense added. It seems to me that this is just normal routine stuff that happens in every case.
Thank you, Your Honor. That is, with all due respect, that is not how I read Instruction 17, and that's not.
Well, why don't you tell me why Mathis allows this?
Your Honor, again, since they haven't even briefed Mathis, I'm
Look,
not well prepared to talk about Mathis. Frankly, I apologize to the court.
Well, the fundamental issue is whether there is a different account, right? Where there's an added count.
That's right.
And you would have to conclude
Yes, Your Honor.
that 841A
Yes, Your Honor.
charges 4 different counts in that provision. That's what you have to conclude, right?
That's what this,
Argument. That would be necessary for your argument.
yes, Your Honor.
All right. And so you're saying 841A is 4 different counts. And it's the recent Supreme Court cases on deciding what's offenses and single offenses.
I think,
And Randall.
yes, Your
And
Honor.
of course, the order of proof in that case, in other words, in that case, obviously possession would not be distribution. You couldn't, the distribution would be an added aspect.
Yes, Your Honor.
Today, we would say it's an alternative means, I think.
I would not say that, Judge. I don't think, I mean, Randall's very,
Well, your statement there just conflicts with Mathis.
well, again, I guess I'm at a loss here because they've briefed it. They
Well,
have,
forget about their briefing. I'm asking you the questions.
I know you are, Judge, and I have to again apologize for not being up to speed on Mathis. It's my fault, I guess. But,
All right.
All right. But I am up to speed on Randall, and that's the law of this circuit in a published decision. And it's clear that these are 2 distinct offenses. That's not just the Fourth Circuit's position. Every other circuit that has addressed this question has viewed these as 2 distinct offenses, even though they're part of the same statute.
Counsel,
Yes, Your Honor.
even if that's correct, kind of putting Mathis aside, it is correct, isn't it, that Mathis went from a more narrow offense, distribution, to a more broad one, possession with intent to distribute. And we have, as Judge Niemeyer said, the flip of that here. Is there a Fourth Circuit or any other circuit case that follows this pattern where you go from the broad down to the narrow in the opposite of the situation in Randall?
I don't know of a case, Your Honor, that's directly on point that flips, that's on our facts, that flips the way this one does. But I would disagree that it goes from broadening to narrow. I think what Judge Jones did is he broadened the indictment by giving the jury 2 choices: either find distribution, actual distribution, or possession with intent.
Let me ask you on that.
Yes, Your Honor.
The instruction, of course, starts out with just the possession. The court tells the jury that the defendant is charged with possession with intent to distribute 500 grams. Then the court says, in order to prove that, the government must show that he possessed with intent to distribute or distributed.
Yes, Your Honor.
Is that an inaccurate statement?
Yes, Your Honor.
Why?
I'm sorry.
Why? If you distribute it, aren't you possessing with intent to distribute?
No, not necessarily. And that's what Randall said. That's what this court has said. It is not necessarily the same. That's why they're 2.
I'm not talking about the same offense, same proof. I'm talking about proof of violation.
No, you can distribute drugs without ever possessing drugs.
How?
You could be a broker. You could be a guard. You could be a supervisor.
You're not distributing then.
Sure. Well,
you conspire to distribute, but it seemed to me you have to have constructive possession to distribute.
in cases,
And you have to have constructive possession to possess.
and I don't know of any case holding that way, Judge Niemeyer. The cases I've cited in my brief hold exactly the opposite. They are not overlapping. There's no, you can distribute easily without possessing actually or constructively.
Well, let's assume you're correct. How do we handle Cotton, Promise, and Johnson, all of which say it's subject to plain error, even though you argue it's structural?
I argue, Judge, thank you, that this is a constructive amendment. Cotton in those cases are not constructive amendment cases. Those are indictment error cases where the indictment leaves out an element and then the judge doesn't instruct on that element. This court has wrestled with the difference between an indictment error such as Cotton and a constructive amendment. And that's Judge King's opinion in Whitfield in 2012, which postdated Cotton by 10 years. And Judge King there said, The difference between an indictment error and a constructive amendment is oftentimes nuanced, but it is substantial. So a constructive amendment in this circuit is a per se error that must be reversed without question. Whereas an indictment error, leaving out an element of a charge, is not a constructive amendment. What we have here is a trial judge that took a charge, possession with intent to distribute, and then constructively amended it by instructing on a different charge, two different charges. He said the jury may find him guilty if it's either possession with intent to distribute or distribution. So that's a constructive amendment. This court in multiple decisions since Cotton, which was way back in 2002, has consistently confirmed the rule that a constructive amendment must be reversed.
Counsel, let me.
Yes, Your Honor.
I have 2 points. I want to come back to what you just said, but before you get there, this case seems an awful lot like our Moore decision, where considering we have a constructive amendment, there was 2 separate prongs of a murder for hire statute, and the indictment was one of them. The arguments from counsel were all on one of them. The verdict form was all on one of them. But in the charge, kind of like this, the judge also mentioned the second element. And we said under the totality of the circumstances, when you look at everything there's no constructive amendment. How is this different than the situation in Moore?
Again, I apologize. I'm not familiar with that case. It has not been briefed by the government, I don't believe. But in this case, there's a separate offense that has been added to the indictment by the trial judge.
It was the same thing, that you could commit the murder for hire under the statute by using interstate travel on the one hand, or you could do it by interstate facilities, mail or wire on the other. And so it's really effectively on all fours. Quite frankly, there was more evidence of the uncharged route in Moore here. Here, there's really no evidence of correct potentially that there can be distribution without possession. Assume that's right. There's no evidence whatsoever in the record of that here. So there's really no evidentiary risk that a jury could have concluded there was some distribution aside from distribution, along with possession with intent to distribute. So, I don't mean to catch you off guard if that's not something you read. I appreciate there's a bunch of law out there. I don't know them all either, but I would submit to you that's pretty much directly on all fours with this, or at least it seems to me to be that way.
Well, thank you, but as recently as this year, in an opinion by Judge Agee, the Fourth Circuit, is called Simmons.
I'm familiar with Simmons.
Right. Said that the law of this circuit is that a constructive amendment is per se reversible without preservation.
But this is what this addresses, whether you get to constructive amendment. They found constructive amendment in Simmons. Now, the government didn't argue the point Judge Niemeyer raised, which is whether Cotton makes Floresca untenable.
Yes, Your Honor.
And that's been briefed, and I hadn't gotten to that yet. But before you even get to that issue, Moore tells you there's not a constructive amendment if we have a language in a charge that arguably adds that's the only thing when you look at the record as a whole that would bring that up.
But again, I'm a little disadvantaged because they haven't briefed Moore, so I'm unfamiliar with it. But here, it's not just adding an element, he's added a distinct offense under Randall.
Yeah, maybe that's
he didn't state it as the offense. He told the jury the offense is possession with intent to distribute. And then he says, in proving that, the government has to show 1, 2, and 3. And in proving that, he said you could show that if he distributed, he possessed with intent to distribute. Now, in the context of this case, that is not necessarily adding an element. That's just an aspect of proof. He could be saying if the man distributed it, or if he manufactured 10 grams of it, or if he, in other words, the court could have outlined all kinds of evidence based on what was presented that would satisfy the proof if they believed it. And in this case, he added the one proof item that if he also distributed the methamphetamine, that that would satisfy possession with intent to distribute. And the question is, you're saying that's adding an element. I mean, that's adding a new offense where the judge posited it as just a proof aspect. He listed the three elements, and that was one of the proof aspects. Then when he submitted the case to the jury, submitted only possession with intent to distribute. And the jury found yes. So there was no, I mean, I don't think there are separate offenses at all. I think it's as clear as a bell under current jurisprudence that 841A is not four different offenses. I mean, we would just never reach that conclusion, I don't think, in today's jurisprudence, but that would be necessary for your argument that 841A defines four separate counts. And with respect to each of those four separate counts, then you have separate counts based on the quantity, which we, of course, we held in promise. The quantities are separate offenses.
Judge, I see my time is up. Can I briefly address?
Of course, if it's okay with the chief.
Yeah, you may.
Thank you. Here's where we are, I think, just summing up. We have an opinion that's published, a very prominent opinion called Randall from 1999 that says there are distinct offenses. They have not briefed this Mathis argument that Judge Niemeyer is outlining for me this morning. So I think this court is bound by a Randall.
Let me ask you something. We don't even need Mathis. If I have a statute that says anyone who assaults, kicks, punches, slaps another person is guilty. Are there four offenses there?
Yes. And finally, I'd just like to say that this judge Judge Jones did not say, you may, he's charged with possession with intent to distribute. You may consider, if you find that actual distribution, you may consider evidence of distribution as evidence of possession. That's not what he said. He said, you may find this gentleman guilty as charged if you find either that he distributed or that he possessed with intent to distribute. He didn't just say you could use it as evidence of possession. He gave them two avenues to convict, and those are two distinct offenses under Randall.
Counsel, I just want to make sure.
Yes, Your
I
Honor.
understand you before you leave. You agree that he was charged with possession with intent to distribute?
Yes.
All right, that's fine, right?
Right.
And now, as you assert that when he said you can convict him if he distributed drugs, you think that it broadened or doesn't make any difference, the fact that it's a new offense, whether it broadened or not?
It did broaden it, but it doesn't make any difference. But I think it did broaden it because it created two bases for conviction. Either an actual possession with intent to distribute or distribution. So we went from one offense.
May I follow up that question? What if the court instructed the jury just as you wished, possession with intent to distribute?
Yes, Your Honor.
And the government only proved 3 transactions where there was actual distribution. Could the jury find him guilty?
The jury could find him guilty if they found the distribution evidence of possession with intent to distribute. They could, perhaps.
I don't, that's double talk. I'm trying to ask you, he's charged with possession with intent to distribute.
Yes, Your Honor.
The only evidence in the case are 3 distribution acts. Could the jury find him guilty?
Well, it depends what the evidence is, but I think
distribution, sales of hardcore sales of transactions where the defendant sold, and that's all that's proved.
Oftentimes, a sale shows possession, evidence of possession. That's
what you mean oftentimes. Why isn't it always?
It isn't because courts.
No, in this case, my hypothetical is there are 3 sales produced. The defendant sold methamphetamine for money 3 times to undercover agents.
Yes.
That proof comes in.
That is
evidence. And that's the only proof in the case. Is there a conviction?
That's evidence of possession with intent to distribute. That's right. And it's also evidence of distribution.
How do you distinguish that from the instruction?
I'm not sure. I mean, these are not our facts. And I go through that in detail in the reply brief. Those are not our facts. This is not a controlled purchase where the guy shows up and sells it to an informant.
They had a lot of testimony of people making purchases.
Well, here that's their merger doctrine argument, but here there's all sorts of evidence that he possessed methamphetamine outside any kind of supposed distribution. So that merger theory that they were trying to employ just doesn't work here. No further questions. This concludes appellant's argument. Thank you, Your Honor.
Thank you so much, Mr. Beers.
Thank you.
Mr. Jones.
Thank you, Your Honor. Good morning, and may it please the court. My name is Jonathan Jones, and I'm here on behalf of the United States. Your Honors, I'd like to begin by discussing the constructive amendment questions and some of the issues that were raised during appellant's argument. I want to begin by noting, I think there was a suggestion that the government had requested this instruction. I want to point out that this instruction was provided by the court. This was not language that the government had requested. But our position is that this is not a constructive amendment of the indictment. I think in particular, given the specific context of this case. I think there's been a suggestion by the appellant that there are theoretical circumstances where distribution could occur without actual possession. And that may be true.
Well, I'm having a hard time following that, because if you distribute without possessing, you would still have to have constructive possession to distribute. It would have to be somebody under your direct control, and you tell them, hand it to them. And if that's so, you're also constructively possessing.
I think
it's beyond me to see how you could have constructive distribution and not have constructive possession, because in order to distribute, you have to pass the drugs from one person to another.
I think that's correct, Your Honor. And I think perhaps even more importantly, the idea of sort of any theoretical non-possession would not apply in this case. There was no dispute that Mr. Banks possessed the methamphetamine at issue here. He was on video running around a hotel with the bags containing methamphetamine. So the question about whether or not he distributed would only go to whether he possessed them with the distributed intent. And that's why.
Let me ask you, when you have constructive amendment, you have to add an offense, don't you?
Yes, Your Honor. So the way the court framed this,
the word I'm focusing in on the word offense and the elements of an offense.
Yes, Your Honor. So in Whitfield, this court said there needs to be a concern that the defendant is actually convicted of a crime other than that charged in the indictment. So you need to be concerned that there was a conviction of a separate offense. A
separate offense. And the question is whether the government takes a position or has a position on whether 841A, which has 4 different means of trafficking in drugs, are 4 separate offenses.
Your Honor, obviously, as the appellant noted, we didn't brief that specifically in our brief here. What I would submit to the court is that we certainly don't dispute that there are different elements for each of those, but under Mathis.
Why do you say they're different elements?
Because possession is not, distribution is not specifically an element of possession with intent to distribute, while it would be an element of distribution, and distribution is not specifically an element.
It may be a fact, but is it an element?
Your Honor, we would submit that distribution is an element of distribution and not possession with intent to distribute, and possession is not an element of distribution.
That's a mighty strange concession, because I basically give away your case.
Your Honor, we don't dispute that the elements might be slightly different, but getting to the point that you're raising.
It's not elements of slightly different, is whether 841 is a single offense or whether 841 has 4 offenses. If 841 is 4 offenses, then he maybe added an offense element here, added an offense here.
Your Honor, our position is that there was no constructive amendment because he didn't add a separate offense here. He referenced the or distribution possession with intent to distribute. I think with respect to the Mathis point, it would be reasonable to look at 841A as including 4 separate ways of committing the same offense. Given, however, how this court has described those offenses, this court has indicated that there are separate sets of elements for those 2 offenses. They're very, very closely related, and that's why we have a merger doctrine. And we certainly raised that in our brief here, but the idea that these offenses can merge is because they're so very closely related. and because there's an enormous overlap in the elements, and in many, if not most cases, possession with intent to distribution will necessarily imply, because then the fact that the merger doctrine.
So on my assault,
You would find that those were alternative ways of.
So, counsel, can I, let's kind of follow the proposition that there are ways distribute without, and so as appellant says, they're separate offenses. Does it matter that there's no evidence? Let me first ask you, is there any evidence in this record, either from the proof submitted or arguments made by the government, that that there was distribution here separate and apart from possession?
Your Honor, the evidence in this case indicated that Mr. Banks and a co-conspirator arrived at the Super 8. They had methamphetamine with them, whether they needed any more meth. And then there was evidence that during the course of that evening, they went to a hotel room and they used the meth that was brought by Banks and his co-conspirator. So there's evidence, I think, that a distribution certainly occurred consistent and together with the possession that was happening.
But there's my question, I might have asked it very clearly. Was there any evidence that Banks did some distribution through an agent or through some third party in a constructive way or anything like that in this case?
No, Your Honor. And that's the point I think I was trying to make earlier, when to the extent there's a theoretical basis for finding that distribution can occur without possession, it certainly did not happen on the facts here. And on the record here, it's clear that there was possession, and any distribution that occurred would show the distributive intent of that same possession.
That's okay. That's what I was. And did the government argue, either in opening or closing, that that Mr. Banks was guilty of distribution based on evidence separate and apart from his possession of the drugs?
Not on this count, Your Honor. There was a separate conspiracy count related to possession with intent and distribution.
Right.
And so there was distribution.
Not on count 10.
Right, but not on count 10. The government argued, and this is at JA 291, and you can look at JA 884 as well, that he was charged with possession with intent to distribute. Our judge very clearly says he's being charged with possession with intent to distribute. Here's what you need to think about in terms of the proof that the government presented, and that's where he references distribution. And just those two words, I think, or distributed, in this case, in this context, given what the government argued, given what the government proved, I think very clearly is simply a way to consider whether or not there was the distributive intent at issue in this case, not a separate offense. And there's no reason to have any concern that he was actually convicted of a separate offense of something that was not charged in the indictment.
Your colleague said, and I can't recall, to be honest with you, whether y'all briefed our Moore decision, or do you know whether you did, and if not, whether you're familiar with that decision, and if you are familiar, do you have enough?
I can't say that I'm prepared to discuss it in depth, but my recollection is that it includes two prongs of the same statute, and the court ultimately found that there was not a constructive amendment, and we think that would be comparable here, and that it would support the argument that the government is making, that it's sort of in the same way that there's no duplicity, there's no constructive amendment of the indictment in this case. Your Honors, if there are no additional questions with regard to the arguments we make about plain error, which would apply only in the instance that the court finds that there was a constructive amendment, but even if there was not a constructive amendment, our position is that under a plain error review, which we believe should not notice the error at a minimum. The Simmons case was referenced by the appellant in his argument, and there were two 28J letters that were submitted to the court with respect to Simmons. Simmons, of note, in a footnote, makes clear that Floresca, which found that per se reversal applies, may no longer be good law. And it declined to reach that question simply because the government didn't ask it to. Our position here, we are specifically asking the court to reach that question if it finds that there was a constructive amendment. And our position is that Floresca, to the extent that it requires a per se reversal, is no longer good law under current Supreme Court precedent. And there's, I think, a few cases that I want to highlight. We cited them in our brief and as well in the 28J letter that we submitted to the court. The Supreme Court in United States versus Young made clear that per se reversal is inappropriate for plain error cases, that it must be done on a case-by-case basis, not on a per se basis. And this court has cited United States versus Young, for example, in Siddell in 1996, echoing that same sentiment that the determination of whether to exercise our discretion to notice plain errors must be made on a case-by-case basis, and that a per se approach is flawed and it's inappropriate. In addition, given what the court said in Cotton, where there was an indictment error and the court specifically applied the 4 prongs of Olano and found that under the 4th prong, at a minimum, the court should not notice the error as the sort of that a constructive amendment should be subject to the plain error review, the same sort of review that was at issue in Cotton. A constructive amendment of the indictment, I think our position would be that they're right to have the grand jury identify what charges you'll be convicted of. And in both situations, in a constructive indictment or an indictment error, the problem is that you've been convicted for something that the grand jury did not find. And so to the extent that an indictment error is not going to qualify as structural and it's not the sort of error that would not qualify for a plain error.
Mr. Jones, if we conclude that Randall is good law and control.
That Randall is good law?
Yeah.
No, Your Honor. I think that given the factual differences between Randall and the qualifies as a constructive amendment of the indictment.
Because of what? A lack of what? Prejudice or what? Can you harmonize your case with Randall? Is it because here you're arguing there's a lack of prejudice or a lack of broadening? What about your bail if Randall is controlling?
The jury to consider what the government would need to prove or had proved in a crime, possession with intent to distribute, that was actually very explicitly charged and very explicitly argued.
I mean, it's a matter of
we can't come down and greet you under the circumstances, but please know that nonetheless, we appreciate your being here and we wish that you will be safe and stay well. Thank you, counsel.
Thank you.
I'll ask the clerk to prepare the court for the next case.
Yes,
Okay.
Mr. Harlow.
No.
The information that we got is just mainly an itinerary that said that the plane was supposed to leave at 11:10 Central Standard Time.
Counsel,
Yes.
this is Judge Quattlebaum. If I could interrupt you just to ask a couple of questions to get something straight. Under seeking jurisdiction under the habeas statute,
Yes, sir.
the available writ of this situation. And so one, I think I'm right that you have that you don't think is adequate and didn't pursue would have been to a deportation. So I understand your concerns about that. But that, in theory, that's one remedy that you would have had or your client would have had. Is that correct?
No, Your Honor.
a little heavy-handedness. In this case, neither you nor the government knew of the stay for several days in the process. was conducted under sort of innocent circumstances. Indeed, the immigration judge found that there was no violation of the order in this case.
That is correct, Your Honor. She did. However, I would assert that as I go back to this requirement, the immigration judge promulgated by the Department of Homeland Security. So these are regulations that that may or may not be subject. They may be violative of due process. They don't care. That's why it's up to this court to say, hey, this rule that says I got to notify the Department of Homeland Security, and the immigration judge doesn't have any rule to tell anybody. I mean, and it's not her fault. She didn't have to tell the parties. That would have solved everything. Just timely notify the parties of a stay. I think that would have been a very regulation to impose. They do have to take all reasonable steps to comply with the stay granted by an immigration judge. That's the rule. That's in the regulation. They put that in there. Doing that. Why are they not implementing a rule where the immigration judge timely notifies the parties of a stay? It seems pretty important. She's put it in her outgoing mail, and there's a lot of things in this case that are kind of crazy. That April thing.
Well, I thought the immigration judge did notify both parties.
She did. She put the notice in her outgoing mail.
Yeah, isn't that notice to the parties?
It is under the current regulations. We're saying that's a violation of due process. I mean, this is an important order from an immigration judge, and just no duty to notify the parties. I mean, timely notify them, make a phone call, do something. I mean, this is not electronic filing in all the immigration courts yet. So nobody, there was no electronic filing. Maybe one day that'll be solved, and we don't have to worry about things like that. But she just put it in her outgoing mail. And there was no notice to the parties. I had an affidavit, and so I forget where it is in the actual joint appendix, but I actually tried to call the court. I was told no stay had been granted. So
I thought that you were told at between 1 and 2 o'clock on that day that the matter was still pending before the judge.
Yes.
Well, that didn't say no stay had been granted. That says it's pending before the judge and centered on that day. We just don't know the particular moment. An immigration judge noted later that it was moments after 11:08 when you filed. But moments is a plural word that could mean any time. But you called it between 1 and 2, and the stay had not yet been entered, according to the clerk there.
Yeah, the court is closed from. The court is closed from 11:30 to 12:30, and so I called as soon as I could. It was just a crazy time. I normally would. All my filings are done in person. I would have filed it in person. This particular case, I emailed the file to the court clerk at 10:30, and then I had no way to file anything with DHS. They had just, by that time, I'd already filed the service by mail. Unfortunate circumstances that all occurred the way it did. However, I still get back to the fact that, there is no duty of the immigration judge to notify the parties. And it's a pretty important thing. I mean, especially in this case where he was on a plane going to be deported. I'm over my time, Your Honor.
All right. Thank you, Mr. Davis.
Yes.
Ms. Grant.
Good morning, Your Honors. May it please the court. Nicole Grant on behalf of the government. The district court did not err in dismissing Mr. Ortiz's petition for writ of habeas corpus after determining that it lacked jurisdiction to hear his claims. The district court properly found that there existed two separate, distinct, and concrete bases through which it was stripped of its jurisdiction. First, Mr. Ortiz filed a petition for a writ of habeas corpus. The habeas statutes require, those found at 28 U.S.C. 2241, that anyone seeking in custody, end quote, at the time in which they file their petition. The record before this court is clear, and Mr. Ortiz does not disagree that he was not in custody at the time that he filed his habeas petition. Mr. Ortiz argues that exceptional circumstances exist, but they do not. Secondly, the district court did not err in determining that alternatively.
Counsel, could I stop you. I just want to make sure that first point, I understand what you're saying. Are you saying that that an exceptional circumstances, that an extreme circumstances exception doesn't exist, or that the facts here do not satisfy such an exception?
Thank you for your question, Your Honor. I'm arguing that the facts here do not satisfy a finding of exceptional circumstances. Singh does make the carve out for exceptional circumstances where individuals who have been removed, where there's a valid stay order in place, can be deemed to not have to comply with the in custody requirement. But in this case, there was no valid stay order at the time in which Mr. Ortiz was removed from the United States.
Well,
Thus, exceptional circumstances do not exist in this case.
Yes, Singh certainly does do that, but we haven't done it, and the Supreme Court hasn't done it. But I take it your position is you're not contesting that exception. It is part of the habeas analysis. You just don't think it's met here.
Yes, Your Honor. The government doesn't have any position on, what this court's view should be on exceptional circumstances existing. We acknowledge that, the Ninth Circuit has found in that case that they do exist. Okay. The government's position is the facts in this case before this court, they do not satisfy an exceptional circumstances finding should this court decide to rely on Singh and accept exceptional circumstances as a basis to sidestep the in custody requirement.
What's your position? I explored a little bit with your colleague about whether an APA claim could be brought, whether or not it's done here, could be brought separate and apart from the habeas statute. Not on the basis that this isn't really challenging the discretionary deportation decision. This is more of a legal attack on the regulations. And in answering that, will you consider the Supreme Court's Jennings case?
Well, in this case, Your Honor, the government's position would be that Mr. Ortiz's APA claim cannot proceed for multiple reasons. One, what was before the court was a petition for habeas corpus. Mr. Ortiz was not in custody. Therefore, the court could not exercise jurisdiction on that basis. The APA does not provide its own independent basis for jurisdiction. Therefore, there would have had to be some other basis for jurisdiction for Mr. Ortiz's APA claim to proceed.
If someone if this claim had not been brought as a habeas claim, isn't the APA a federal question jurisdiction? Are you saying that's not an independent, that you couldn't claim federal question jurisdiction under the APA? Now, I know there's a question about whether we have jurisdiction or not, but isn't that a valid federal question?
Well, if Mr. Ortiz would have filed a complaint,
Fair enough. I know that wasn't done here. I'm talking about in theory.
Well, in theory, he could have challenged. In theory, you can file an APA claim in an immigration case. However, in this one, he is challenging, what 1252G we would argue would not allow him to challenge before courts, which is ICE's ability to effectuate a removal order. And so the government's position would be that, no, he would not be able to challenge, he would not be able to bring that challenge before the court.
How does that square?
Does that answer your question?
It does, but how does Jennings apply or not apply to that position?
Well, Jennings stands for the proposition that there are limitations on, what can be brought before the court.
Well, it stands for the proposition, I thought, that is the case, but the general jurisdiction bar applies to discretionary decisions, not legal challenges to the regulatory or a statutory framework.
But the government would argue that, Mr. Ortiz's claims are challenging his removal order, ICE's ability to carry out that removal order, which is in fact a discretionary decision that ICE has the ability to make, and thus Jennings would not allow him to bring that challenge.
Okay, thank you.
Ms. Grant, your position that the extreme circumstances are not met here because of he did not simultaneously file a habeas or what at the time or what?
Well, yes and no, Your Honor. So as a threshold matter, the government argues that extreme circumstances do not exist here because Mr. Ortiz, because there were many opportunities for Mr. Ortiz to have filed his motion for stay. He waited until the very morning to file it. He could have filed it on March 10th when he was initially placed into immigration proceedings. He could have filed it on March 20th when he was interviewing with the consulate to get his travel documents. He could have filed it on March 30th when he was transferred to Louisiana, as he stated, to effectuate his removal. He did not. He waited until the very morning to file his motion for stay. The regulations controlling motions for stay are clear, Your Honors. Those found at 8 CFR 12 or 241.6C. Sorry, Your Honors. Yes, the government has to take all reasonable steps to comply with the valid stay order, but there was no valid stay order in this case because, as the regulations go on to say further, the order only becomes valid if it is signed prior to Mr. Ortiz having boarded the plane and normal boarding having completed, or more importantly in this case, if it had been communicated to the agency so that they could take some action. Extreme circumstances existed in Singh because, as Judge Niemeyer mentioned, DHS was aware in that case that a state order had been issued, and they acted in contravention of that state order. In this case, Mr. Ortiz does not deny that the government was not aware of the state order until 2 days later. Further, the government would argue that any exigency that existed in this case was exigency created by Mr. Ortiz because he waited until the very morning of his removal to file the motion for stay.
That's true, Counsel. Your point of best practices is well taken. But when we talk about, in a sense, of jurisdictional aspect of the order existing, we look a little question there is whether or not, notwithstanding him being late, the question is, at the time that the order was entered, a stay, he was in the United States, was he not?
No, Your Honor, the facts do not show that at the time the stay was entered, he was in the United States. As Mr. Davis stated in his declaration, the understanding was that, it was signed some moments after he filed it. As Judge Niemeyer.
But where was he? I mean, it's not a trick question. I mean, when it was filed, where was he? When the order was entered, where was he?
When the motion was filed before the court, yes, he was in the United States.
That's what
the record shows that it was filed at 11:08 a.m. However,
Right.
the filing of the motion to stay is not what puts the duty on the government to comply with the motion to stay.
Not just the filing, but when the order was signed or entered, was he in the United States?
That is unclear, Your Honor. It's unclear whether or not he was physically in the United States at the time that the order was signed. But assuming arguendo he was, let's assume that the order was filed at 11:09. He still would not comply with the regulations because the regulations require that it not only be signed, but communicated to the agency prior to him boarding and, normal boarding having concluded for it to be a valid stay. So here we have a stay that was filed moments before the flight took off.
Right, but that may be this normal boarding, whatever that means. But in terms of the habeas talks about in custody. So for that, you could still be in custody in the United States, but still under your rules, you're here, but the normal boarding proceedings have concluded, right?
Well, Your Honor, the in custody language does not attach to the regulations controlling stay. The in custody requirement is a habeas requirement, and he must be in custody at the time that he files the habeas petition.
Right.
He was not in custody at the time that he filed the habeas petition. The government lawfully removed him on April 1st, 2020. He did not file his habeas petition until May 12th, 2020. That is why he does not satisfy the in custody requirement. But as it pertains to the state order was invalid because it was not communicated to the agency prior to.
Exactly. Well, no, this is a case where nobody's at fault. The question is it extreme because of the circumstances? He didn't have a chance to fully vet through the process the change of status that he was seeking. Because of not, as you say, not as a fault of the government. ICE didn't know, and someone put it in the mail, and as Counsel Wells says, that's very important stuff. Put that in the mail. That's like somebody's, dying of poison. You say, okay, good, I got the antidote, but I'm gonna mail it to you. I mean, you got to get it to them. But it's no one's fault. But doesn't it make it extreme in a sense that we're talking about a person's life, and these things are important? And why wouldn't that be extreme? Does it have to be someone's fault to be extreme?
No, Your Honor, it certainly does not have to be someone's fault to be extreme. And the government acknowledges that, the circumstances they played out here are unfortunate. However, the regulation is clear. And in this case, the state order just never became valid because it did not comply with the regulations. The government was not aware of this, not being aware of the state order when Mr. Ortiz was removed, is a secondary issue. The primary issue being that in order for the state order to have been valid, it had to have been communicated to the agency prior to him boarding the flight and prior to normal boarding concluding. And that is not what happened here. Moreover, as unfortunate as it was, Mr. Ortiz is not foreclosed from, challenging his removal. The second basis that the court found that it lacked jurisdiction, the Real ID Act being 1252A5 and B9, that states that any claim arising out of removal related activity should be brought before this court through a petition for review after determination by a Board of Immigration Appeals. And the government, is aware that Mr. Ortiz is still carrying out actions to challenge his removal. He has since filed an appeal of the IJ's decision to dismiss his case. That went up to the board, and the board remanded, and it was before the IJ again. The IJ issued a second decision that he has now appealed again. And depending on how that decision plays out, it could be that the BIA decides to reopen on its own, or the BIA could deny the motion, and Mr. Ortiz could follow the proper steps and file a petition for review before this court and make all the arguments that he's tried to make in a habeas petition where the court just could not exercise its jurisdiction.
Or perhaps the United States government might join in not opposing that motion to reopen for the BIA, correct?
Your Honor,
you represent the United States government. Is the government position that situations like that, and you said it very well, very unfortunate situation. Would this might perhaps be a case where the government would do that?
Your Honor, I cannot speak for what ICE will do. They're a completely separate agency with their own decision-making processes. But I do note for the court, while this was unfortunate in terms of how things turned out that particular day, this was not unfortunate in terms of how Mr. Ortiz delayed in seeking relief before the immigration court. Mr. Ortiz entered the United States in 2013, and his removal order became final in 2015 when he did not appear for his removal proceedings. So we're talking about from 2015 to 2020, where he could have filed a motion to reopen his proceedings to seek some relief from removal. He did not file anything for 5 years and waited until April 1st, the morning of his removal, to file both a motion to reopen and a motion to stay his proceedings. To stay his removal. So there were many opportunities in that 5-year period for Mr. Ortiz to seek the relief that he wanted before the immigration court in terms of, relief from removal. But moreover, there were many opportunities while Mr. Ortiz was still in government custody for him to have filed his habeas petition, and he did not. He was transferred into immigration detention on March 10th. From March 10th to March 30th, he knew that he was going to be removed. And he chose not to file a motion to stay his removal until April 1st, 2 minutes before his flight took off. And so, yes, the government does agree that the facts of this case, in terms of what happened on April 1st, are unfortunate. But as the government has stated before, the exigency that was created in this case, not only that day, but going back to 2015 when his removal order became final, these were actions or inactions, I should say, taken by Mr. Ortiz himself.
Counsel, what's your, I know you have two independent bases for saying there's no jurisdiction to consider the merits of the issue. So I'm not, by asking this, suggesting you're not right or that you are right on that. But Mr. Davis talks about, you have a regulation that is based on boarding a plane that seems to be, or at least is asserted to be, based on a historical way of deportation through commercial airlines. Is it not unreasonable to use procedures that applied to a deportation method that doesn't even exist anymore as the basis of determining whether an order of stay is effective or not?
The government's position would be no, only because what is important in that scenario is DHS being notified that an order of stay has been granted. And so whether the flight is one that is commercial or one that is, controlled by ICE, unless ICE is aware, there can be no steps taken to.
But the notice doesn't counsel that it's not just notice or communication, it's communication before boarding, if I recall. Maybe I'm wrong on that. And so the boarding matters. I mean, by the time he's here, it may not matter as much because the notice happened, was received 2 days later. But I mean, there could be facts where, that are different than these. So I'm trying to get to the merits of basing communication, basing notice before boarding, which seems like saying notification by facsimile or some method that's just not used anymore. And if that's the case, is that not unreasonable, assuming there's jurisdiction to get there?
Your Honor, I'm not comfortable taking a position on whether or not, that is reasonable. The regulations are as they are. In terms of, reasonableness in this case, the government's position is that, the stay order was not ever valid because of how the facts played out here. But in terms of,
the question of reasonableness, I'm just wondering, thinking along with that question, it seems to me the question of reasonableness about the regulation, the unreasonableness would depend on whether the government was manipulating the time. And it seems to me the only way it could be manipulating the time is if it knew there was a stay order coming or was there. In this case, and in that case, that might be exceptional because in the Singh case, the government was aware and the order was a valid order. And in this case, the order was not a valid order under the regulation and the government wasn't aware of it. And so it seems to me the regulation would be measured by the same notion. If the government knew of the stay order and started manipulating the departure, obviously, there's a problem there, but it also would be ignoring the stay order as opposed to following the regulation at that point.
Court's indulgence, I see that my time has expired. Is it okay if I respond to Judge Nehemiah and conclude?
Yes, you may.
I agree completely with you, Judge Nehemiah. There was no claim that the government was or has manipulated, its its departure times to invalidate orders of stay. Mr. Davis and Mr. Ortiz were provided with the flight departure manifest that showed when the flight took off and when the flight landed. And there were no allegations that that was, in any way doctored. I would argue that there would be no reason for the government to doctor these documents, because if there is a valid stay, the government does want to comply with the regulations and to ensure that it is acting to, not violate the law. And so in a circumstance where a stay is valid and that is communicated to the agency prior to the flight boarding, I would argue that the government is going to follow the regulations and, take reasonable steps to comply with that stay order. If there are no further questions, the government asks that this court affirm the district court's decision below. Thank you so much.
Thank you so much, Ms. Grant. Mr. Davis, you have some time reserved.
Yes, Your Honor. What I would say is, first, we're not alleging any type of manipulation by the government. However, as we tried to get discovery on when that plane actually boarded and when that plane actually departed from that airport, and we were not able to get that. The judge shut us down because that document on page 84, I believe it's 84 of the joint appendix, is just an itinerary. It shows when the flight was supposed to take off or depart. We actually don't know that because it's just an itinerary. That flight could have actually left early or it could have left a half hour late. We actually don't know that. And that was something that we tried to ask we tried to get discovery on the government on exactly when that occurred. But we're still not arguing that the government did anything, manipulative here or did something that they ignored a stay or anything like that. We're simply arguing that the stay regulations are unfair. They are unfair to respondents like my client who did get a judicial stay. And it seems like they could, if the United States government, the most powerful government on the world, if they wanted to do something, they could do it. They could have called down to that plane. They said, you know what, we got to stay. The judge just let us know we got to stay. It just got signed, get him off the plane. Or even if he landed in Honduras 2 hours later, that still could have, there's nothing that the government is going to tell me that they don't have the power to tell that flight to bring that guy back. So I do believe that there's nothing that the government did untoward here, but by not imposing or not promulgating regulations that make the IJ, let us know about these stays as soon as possible. I think that was the linchpin of the case. And I, as I said before, I think it's the regulation as the government is standing on is very unfair. Talking about a boarding process, there was a boarding process in Phoenix, Arizona. There was a boarding process in Louisiana. Are they saying that somebody that did a boarding process in Mesa, he can't, and if he gets to Alexandria, he can't assert a stay? That's preposterous. It's based on 25 years old processes in the commercial airline industry, and it needs to be changed. So the other thing too is, Your Honor, I will tell you, I filed that motion as soon as I possibly could. There's no way that you can just file a motion to reopen and just just throw it in there. It has to be. I've been doing this business for a long time, and you have to have those motions. They have to be perfect. In this particular case, we had to come up with an asylum claim for my client. We were waiting on documents from outside the country, and my client was detained. We did the best we could, with all these COVID problems going on. I filed that motion as soon as I possibly could. There was absolutely no waiting around whatsoever. I knew the clock was ticking. I told my client to call me if they changed his custody. He did. We knew we were on the clock, and we got in there as soon as we could. It just happened to be that it just, it was as I said, it was a crazy time. April 1st, the COVID was going on. It was nuts. The courts were closing. Instead of just going down to the court and filing it, which is what I normally do, I had to email it. I emailed it at 10:30 in the morning. It finally got to the judge at 11:08. It's just it wasn't anything that I was sitting on anything. I filed that as soon as I possibly humanly could. So I don't like the fact that anybody's asserting that I malingered or did something that in any way harmed my client, because I know from years and years of experience of dealing with detained people, you're always on the clock. You've got to get those motions in there, and you've got to file them as soon as possible. If there are no further questions, Your Honor, I hope that you will reverse the decision of the district court, who plainly said the Fourth Circuit has never said anything about this exceptional circumstances. And I hope you do find that. And one other thing, Your Honor, I do want to say that there are just circumstances. I mean, and I don't know that I can actually take this back up to this Fourth Circuit based on what happened in the immigration court. The immigration court did not conduct an evidentiary hearing. She just based it on facts that she knew at that time. I have a feeling, so that's why I filed the habeas, because I wanted all the facts of this very close timing to be adjudicated in that court, so that the issue would be completely preserved for the court, all the facts. No further questions, Your Honor.
All right. Thank you, Mr. Davis and Ms. Grant.
Thank you.
Appreciate your fine arguments. And well, we couldn't come down and greet you anyway, because you're somewhere in cyberspace. But understand that the sentiments of that and appreciation certainly is as well. And I wish you both be safe and stay well. Thank you so much.
Thank you, Your Honor.
Thank you, Your Honors.
All right. Take care, Ms. Bolton.
All right.
Ms. Grant.
You too, Mr. Davis.
All right. Thank you. Cabinet, you may proceed.
I could remove my mask, Your Honor.
Yes.
I have a low voice.
Good.
Thank you, Your Honor, and may it please the court, Chief Judge Gregory, Judge Niemeyer, Judge Pottlebaum. The district court's two independent reasons for denying Mr. Hargrove's compassionate release motion both contained errors. On the
Could you
first
just
reason,
speak up just a touch?
yes, Your Honor.
Thank you.
The first reason the district court gave for denying Mr. Hargrove's motion was it found that extraordinary and compelling circumstances were not present. And the second alternative grounds was that the 3553 factors did not justify a reduction. I'll take the extraordinary and compelling circumstances aspect of this first. The district court, basically, everybody I think agrees on the framework. This is a COVID case. Mr. Hargrove was sentenced to a total of 108 months back in 2017. The pandemic hits. He had 3 medical conditions that were documented that we argued would have increased his risk of severe complications if he were to contract COVID. So it was obstructive sleep apnea, asthma, and a high blood pressure. So everybody agreed that the framework here is to avoid Mr. Hargrove dying, essentially. And that is the probability that he would catch COVID, and then the probability if he caught COVID that he would suffer a severe complication, either severe illness or death. But within that framework, the district court's order really restricted itself only to the CDC's highest level risk categories. And the conditions that Mr. Hargrove suffers from did not fall within the highest risk, or sorry, the level of risk that has the most certainty for people that, quote, are at risk. Instead, it fell in the second tier, which is categories where the CDC didn't have sufficient information to conclusively say that there's a higher risk, but it indicated there might be a higher risk because of the data. Regarding obstructive sleep apnea, we submitted 2 preliminary studies that indicated there is a correlation and there may be an increased risk. And the district court's answer to that was simply not to consider it because it was not in this highest tier CDC category. That is, in our argument, an abuse of discretion. Discretionary decisions require an evaluation of the entire picture and the whole circumstances. It is not compatible with bright line rules. And a district court simply saying, if it's not in the highest CDC category, then it can't factor in, is an abuse of discretion. It's as if a district court were to say, well, you know, this case involves, at a sentencing, this case involves heroin, and I never give less than 5 years in a heroin case, right? Then it wouldn't matter how much mitigation is on the other side. You can never outweigh that bright line rule and that fast and hard rule. And the district court's order, especially pages 129 and 130 are really where the reasoning occur. But its order reflects that it would not even consider these conditions as increasing his susceptibility to severe complications from COVID. I should note at this point, I think there are, in a lot of cases, the government had been, especially last year in the middle of the pandemic, and I think more recently, but the government had been conceding in district court that asthma and certain of these even second tier CDC category conditions constituted extreme and unusual circumstances, and then simply arguing about the 3553A factors. In this case, the government did not concede that extreme and unusual circumstances were present in the district court, but its reasoning was reversed. It said that there wasn't a risk that he would catch COVID in the first place. Now, the district court, in fact, found that Mr. Hargrove was at risk of catching COVID. He was, when I initially filed the motion, he was at FMC Devens in Massachusetts, a federal medical center. While the motion was pending, he was transferred to Yazoo City, Mississippi, into the middle of an outbreak, Your Honor. And we submitted those documents. So the district court found, yes, he's at risk of getting COVID. So really the only analysis left to do under the agreed framework was how likely is it that he's going to suffer severe complications when he does get it. And I should note, since the appeal's been pending, he's now again been transferred. He's now at FCI Hurlong out in California for whatever reason. So his family's all here in Richmond. He's been at Massachusetts and then Mississippi, and now he's out in California.
So your argument here is that not that the fact that they might versus, or not the fact that you couldn't consider that these aren't the highest risk, as I understand it, you wouldn't deny that could be part of the analysis, but to the extent there's a bright line requiring the highest level of risk, that would be legal error.
Yes, Your Honor. I think it would go in the phrase that the district court's like, it would go to the weight of the evidence or the degree of how extreme is this exactly. But it would not, and to be clear, this is a procedural error we're arguing. We're not arguing that this automatically and must qualify on these facts as extreme and unusual circumstances. It's just that the district court has to consider and factor in the fact that he has sleep apnea, the fact that although the science is not well developed, there are studies out there showing a risk, and then the combination of these three conditions any one of them might contribute to the risk of a severe illness. I'd like to move on to the second error that we allege, unless there are any questions regarding the extreme and unusual or extreme and compelling circumstances. The second error is the 3553A factor analysis. The first argument is that the district court failed to adequately address the argument regarding Mr. Hargrove's post-sentencing rehabilitation. And I understand the government filed a 28J motion citing cases that were decided after the initial briefing, Kibble and High. The district court, in its order, holding that the 3553A factors counseled against a reduction, gave one sentence to the evidence we submitted. He says, although the court congratulates or commends Mr. Hargrove for his self-improvement. Right? But the actual evidence we submitted was his wife scheduled for surgery. I actually filed in a supplement. The fact that his wife, they were in a relationship at the time he was initially sentenced, but they actually got married. She went up to FMC Devens and they were married while he was in custody. His stepson, her child that he had been living with and helping raise, died when we submitted the obituary. He completed not simply a few programs, he completed every program that he had access to, including and most importantly, the non-residential drug and alcohol treatment program. And his disciplinary record, which we also submitted, was completely clean, not a single, even minor violation. These are all, and the way that these were all supported by documents from the Bureau of Prisons, medical records from his wife, and the district court simply did no weighing of those against the admitted seriousness of the offense and the gravity of the situation for which he was originally sentenced. The case law on this, we're arguing this falls much more closely under Martin and McDonald, which are also 3582 situations where the defendant presented a substantial amount of post-sentencing rehabilitation, which just got no mention or no weighing from the district court. The district court acknowledged it, said, I considered it, and then denied the motions without sort of explaining or saying whether and how this evidence moves the ball. In this case, the district court's order simply said the factors of under 3553A that led the court to impose that sentence remain. Well, that's going to be true in every single compassionate release case. The original, we're not questioning the original analysis. The question is, has anything changed? And if you look back, we included actually the original sentencing transcript in the joint appendix. This was a difficult case because Mr. Hargrove, the district court characterized him as it's a Dr. Jekyll and Mr. Hyde situation. Because on the one hand, while he was on supervised release, he was working, he got a good job. He was working 12-hour shifts. He managed to move his family out of Gilpin Court and out of the housing projects and out into the county and get them a house. He was supporting not only his partner, Natasha, but all of their children. And he was on that side doing really well. But on the other side, one of his old Confederates from down in Gilpin Court called him up and, unknown to him, obviously was working as a CI, but asked him to get some heroin for him, which he did, obviously. But the simple fact is, this was already a case where there were both strong aggravators and strong mitigators. And so this is something that weighed more heavily on the mitigation side after the sentencing in circumstances that had changed.
But counsel, if I could follow up on something you said, that the 3553A factors remain and that applies in every case. Doesn't High and Kimball, when considered in conjunction with Martin, suggest that the length of time of incarceration matters? And yeah, for example, in Martin, I think the defendant had been in prison for a couple of decades. So when those factors, they remain, but when they're recent, it makes a difference.
That's fair, Your Honor, to say. I think Mr. Hargrove got to the BOP, I believe, in early 2018.
Couple years of
Right. So he'd been in 4 years as of day after tomorrow, but at the time we filed this motion, 3 years and change. That is true, Your Honor. So if it's a very brief time and they don't have time, there's only a couple certificates, that would be one thing. But I think it's not just the time, it's also the level of effort that's put into it. And even in the brief time he was there, he did so many programs, a lot of them health focused. Clearly he's attentive to his health. And a lot of them focused on combating the drug addiction that the court had heard about. Basically, he had a foot injury. He'd been prescribed opioids, and then he was using about 6 pills a day around the time of his arrest. And so completing the non-residential drug and alcohol treatment program, which is the second most rigorous program, the most being the residential drug and alcohol treatment program, was, especially in the short amount of time that he was in prison, was a significant accomplishment. In addition, of course, during COVID, a lot of the programming was suspended simply because it couldn't congregate together for those classes. So yes, I agree the amount of time is relevant, but a lot of work in a short amount of time can still, I think, weigh on that factor. And it at least deserves some kind of analysis in the order from the district court. Some kind of mention about acknowledging not only that, he's taken these efforts, but why it does not move the 35-3A factors, why it doesn't shift the balance even a little bit on the scale of mitigation. The last issue, Your Honor, is the use of just punishment and promoting respect for the law as their consideration in denying the reduction just as to the supervised release violation. And after rereading all the briefs in this, I do realize in the district court I did not explicitly cabin the analyses between the new sentence and the supervised release case. It was, in fact, though, the subject of an appeal, a prior appeal, and it was explicitly on the record at the original sentencing. So considering, as I think the court should, the record as a whole, the issue had been raised, our position had been made quite clear to the district court. 3583 lists, and this is for supervised release, the initial imposition of supervised release, and for the sentence on any revocation of supervised release, does not reference all of the 3553A factors. It omits the retributive factors, just punishment, promoting respect for the law, and the need for the sentence to reflect the seriousness of the offense. It preserves, of course, protecting the public and deterrence. But when the district court denied this motion under 3553A on the alternative grounds, it explicitly stated that the sentence it originally imposed sufficiently accounted for deterrence, the need to promote respect for the law, and the need to reflect just punishment for the offense. The argument here is 3582, under which this motion was brought, says that the district court has to consider the 3553A factors to the extent that they are applicable. And in reducing a supervised release sentence, those 3553A factors are not applicable. They shouldn't have been applicable at the original sentencing, and they are not applicable in deciding whether to reduce the sentence. In other words, they can't be invoked to sustain a sentence where they were never the basis for imposing it in the first place. Tapia, this court in Crudup said the district court is not authorized to consider those factors. The Supreme Court, even in Tapia, was quite explicit that the omission of those factors means that they cannot be considered. I see my time is up, so I'll cede to the government counsel.
Thank you, Mr. Camden. Ms. Bashara.
Good morning, and may it please the court. Jacqueline Bashara for the United States. Can you hear me all right?
Yes.
Thank you. There are two independent and sufficient reasons why the district court did not abuse its discretion in denying the defendant's motion for compassionate release. First, the district court properly relied on guidance issued by the CDC to find that the defendant had not established an extraordinary and compelling reason based on a particular susceptibility to COVID-19. Second, the district court did not abuse its discretion in relying on the 3553A factors.
You're going to keep your voice up, right? We're across the room.
Yes, Your Honor.
Thank you.
In relying on the 3553A factors to find that a sentence reduction would not be appropriate just 2.5 years after it had imposed its sentences in this case. This court can affirm based on either or both of those findings. Turning first to the extraordinary and compelling analysis, this court made clear in McCoy that 3582C1A sets an exceptionally high standard for relief. Now, in navigating the novel legal issues presented by the COVID-19 pandemic, courts across the country have relied on the CDC's guidance to assess whether a defendant's medical conditions make him particularly susceptible to experience a severe illness from COVID-19. And indeed, at least 4 circuits in published opinions have upheld district court decisions relying on the CDC's guidance to assess particular susceptibility. For that reason, the district court did not abuse its discretion in relying on the CDC's guidance here. If the court has no questions as to the extraordinary.
I do have a question there, Ms. Bashara. Relying certainly is a factor. Obviously, it's a very important thing that our nation relies on to some degree in the CDC. So certainly can't criticize the court for doing that. But the question is relying on it in the sense of the strata that it had found none of them equal to the highest level, but recognizing all of them, though, were likely to be indicated as susceptibility to more complicated or severe symptoms or implications of contracting COVID, right? He made that, none of them made the top tier. You agree with counsel's assessment that Mr. Camden's assessment or not?
Your Honor, I would dispute the defendant's characterization that the district court applied some kind of bright line or categorical rule. I think we should look at the district court's ruling in context. And in particular, I'd point the court to 2 things. At JA 130, note 6, the district court said that the defendant had not actually established that his asthma was moderate to severe as contemplated by the CDC's guidance, but the court would assume for purposes of this motion that it was at least moderate. And then at JA 131, note 7, the district court went on to say that even a condition on the CDC's list of conditions that definitely increase risk may not amount to an extraordinary and compelling reason if it is not sufficiently extreme. So that, taken in conjunction with the district court's overall assessment of his medical factors, indicates that what the district court was really trying to do was to assess the extremity, the severity of his medical conditions. It's not just the existence of a medical condition that makes someone particularly susceptible. It's how that condition presents itself, how the defendant experiences it on the day-to-day, whether it is interfering with normal activities, and the way that it manifests is what would interfere negatively with COVID-19. And that's what we should rely on the district court to assess as a fact finder in the first instance.
And what did the fact finder, the court, find about his symptoms or his daily activities
Your Honor,
that would say that he was not?
I apologize for.
No, go ahead. What was it?
So, Your Honor, the defendant simply did not introduce any evidence that he was suffering adverse symptoms from any of these conditions, right? It is true that BOP, his medical records indicate that he was diagnosed with asthma. Now it says unspecified, so we don't know what that means. We don't know the severity. There's no indication of the frequency of asthma attacks or waking up with difficulty breathing or anything like that. He was also diagnosed with sleep apnea. What we know is that BOP provided him with the CPAP machine, and the records indicate that it works well for him. All he needed were new filters, right? And then he was not, in fact, diagnosed with hypertension. That is his position. He believes that his blood pressure is high, but there's no hypertension diagnosis and there's no indication that his blood pressure is somehow causing him to experience some kind of illness or suffering that would interact negatively if he were to contract COVID-19.
Well, we do know that COVID attacks the lungs, right?
Yes, Your Honor, but the defendant, the words particular susceptibility have to mean something in this context, right? It can't just be hypertension in the abstract. It is the defendant's experience of hypertension and whether that in fact makes him more likely to have an adverse interaction with COVID-19.
Well, hypertension is elevated by, in part by inflammation in fluids, right?
Your Honor, I can't presume to be a medical expert at all, but I will remind the court that he was not diagnosed with hypertension.
What'd you say?
He has never been diagnosed with hypertension.
I thought you said he did have hypertension.
No, that's his position.
There's
Based
nothing in
on
the record that said
isolated
he
blood
has
pressure readings,
hypertension.
but there is no diagnosis in his medical record of hypertension.
That's just purely an allegation with nothing in the record about being treated for any of those medications for high blood pressure.
He's not, no, Your Honor. I mean, you can see that BOP is treating his other conditions. For example, the record indicates that he has a vitamin C deficiency, and so they have prescribed medication for him on that front. But if he were diagnosed with hypertension, and I could say I've seen this in other defendants' medical records, BOP frequently prescribes something to alleviate the symptoms of hypertension, but we don't have that here because he was not diagnosed as such.
Okay.
Okay. I'll turn now to the 3553A factors. My friend's first contention was about the district court's failure to fully discuss the defendant's rehabilitation evidence. Now, as he acknowledged, since the parties completed their briefing in this case, this court held in high that Chavez Mesa controls, and so there is no categorical explanation requirement in the context of compassionate release decisions. Instead, depending on the facts of a particular case, it is enough that the district court set forward enough to allow for meaningful appellate review. And I want to flag 4 features that this case shares with High that illustrate why the district court's explanation was sufficient here. So first, like in High, this was a relatively straightforward motion based on COVID-19. Second, the court was aware of the defendant's arguments. Indeed, it appointed counsel to represent the defendant, and it had this motion fully briefed before it ruled. Third, the district court sufficiently considered the sentencing factors. And I say that because we need to look at what this court upheld in High. In High, similarly, the defendant came forward with some evidence of his post-sentencing rehabilitation. Now, the district court in that case didn't actually expressly address his rehabilitation evidence. Instead, all that the district court said in High was that it had very recently sentenced the defendant, that at the time of the underlying offense, he had just been released from state custody for a violent crime, and that at the time, the 3553A factors simply did not support a sentence reduction. But here, we have even more than that. The district court thoroughly considered the sentencing factors, including the nature and circumstances of the offense, the defendant's individual history, the need to provide just punishment and promote respect for the law, and to provide adequate deterrence. Then the district court here went even further than the district court in High, and it expressly commended the defendant on his efforts at self-improvement during incarceration. However, it ultimately concluded that the 3553A factors simply did not support a sentence reduction. Fourth and finally, we can see that the district court had an intuitive reason for denying the sentence reduction here. Like in High and in Legree, it was the same district court judge who presided at sentencing and who ruled on the motion for compassionate release. And at sentencing, the district court selected sentences at the top end of the guidelines ranges for both the distribution offense and the supervised release violation. Moreover, the court chose to run those sentences consecutively rather than concurrently, and it denied the defendant's request for downward variances with respect to both sentences. Therefore, in the words of this court in High, it is not surprising that only 2.5 years later, the district court determined that a sentence reduction simply would not be appropriate. Finally, I'll touch on my colleagues' arguments as to the district court's decision denying the request to reduce the revocation sentence. In Webb, which was in the context of original imposition of a supervised release revocation sentence, this court held that it is not procedural error for the court to consider the 3553A2A factors so long as they are relevant to and considered in conjunction with the factors that 3583E expressly authorizes the district court to consider. And this court explained that that is the case because those 3553A2A factors are intertwined with the factors that 3583E instructs the district court to consider. So what the district court did here was perfectly consistent with High. Yes, it did talk about the need to promote respect for the law and to provide just punishment.
What about what the statute says in terms of all of those considerations it says only those to the extent that are applicable?
Yes, Your Honor.
And the court mentioned ones that are not applicable, correct?
So, Your Honor.
Am I correct about that?
I would like to tell you what the government believes to the extent they are applicable.
Let's get the record first.
I'm
correct.
sorry?
The judge did mention factors that are not applicable by the words of the statute.
Your Honor, we maintain that in the context of a compassionate release decision under 3582C1A, the district court can consider all of the 3553A factors to the extent they are factually applicable. We do not understand those words to superimpose some kind of additional legal criterion or to cross-reference 3583E.
They must mean something. When Congress write those statutes, it says to the extent applicable.
Absolutely, Your Honor. I agree with you on that point, and I think there are two indications as to what Congress was trying to do here. First, 3582C1A, that language, consider the 3553A factors to the extent they are applicable. Congress used that identical phrasing in 3582A, which governs the factors that a court should consider when imposing a sentence in the first instance. The Supreme Court has told us, generally, when Congress uses the same words in different provisions of the same section, there's a presumption that they mean the same thing.
Except for in Johnson. No, go ahead.
Okay. So that suggests that it would be very strange, and there's no evidence here. I have located no authority to suggest that 3582C1A means something different than 3582A. The second point, Your Honor, in terms of what Congress was trying to do here, we can see in 3583E that Congress knew how to limit which factors a district court considers at certain stages of a sentencing proceeding, right? It expressly limited the factors in that provision with respect to supervised release sentences. But it didn't do the same thing in 3582C1A. That's powerful evidence that Congress did not have in mind the interpretation that my friend on the other side offers.
What does it exclude then? Because based on your argument, it doesn't exclude anything.
Your Honor, we would maintain that it excludes factors that aren't relevant. For example, the need to provide vocational training may not be relevant in a particular case, but that's in the district court's discretion, and that's typical of any sentencing. It looks at which factors might be relevant depending on, the offense conduct and the defendant's characteristics and so forth.
It didn't say relevant, right? It had the ones that apply.
Right, to the extent they're applicable.
So that's your position that the interpretation of what Congress meant was there's no restriction, it's just whether or not the district court finds, I think this is relevant, I'll do it. So that's your argument?
Yes.
That statute poses no restriction in terms of factors to be considered for parole violation sentencing, correct? Is that your position? That it replaces no restriction other than the fact that the district court decides what is relevant, what is not.
So we're focusing on 3582C1A.
I know, that's right.
Okay,
exactly.
Yes.
Right.
So our position, yes, it's that it is not an additional legal requirement. It is just a factual limitation.
So what if, and I understand, what if we disagree with that? What if we think extent applicable refers back to the listed provisions and the ones that contain respect for the law and just punishment are not part of them? What if it's a legal restriction and not a factual restriction. What's your position if that's how we were to rule?
Your Honor, if you were to determine that there is some kind of cross-reference to 3583E here, we would maintain that consistent with this court's decision in Webb, the district court still did not abuse its discretion or plainly err, depending on whether this court finds that the issue was preserved, because it did talk about certain 3553A2A factors, but it talked about them in conjunction with and as relevant to other permissible factors like the nature and circumstances of the offense, the defendant's individual history, and the need to provide adequate deterrence. So under Webb, that there simply was not procedural error, even if this court thinks that 3583E applies to the 3582C1A decision.
Does it matter that the district court's order is looking at, the compassionate relief motion with respect to not just the revocation, sentence, but also the independent heroin sentence? In other words, you have not just a violation of the supervised release and the sentence associated with that, you have the independent crime of distribution. Does it not? Is that relevant to our consideration?
That might return us to our invited error argument, because that is how the defendant briefed it, right? He filed the same motion with respect to both sentences, and part of his argument was that granting the sentence reduction here would not amount to a significant variance because the court could just treat it as if it was running the sentences consecutively. So in a way, the defendant was inviting the district court to analyze them together. If the court has no further questions, we ask that you affirm.
Thank you, Ms. Bashara. Mr. Camden.
Your Honor, picking up where my colleague left off, I totally will take the blame for if there is any confusion in the record, and I will obviously in the future, I'm going to keep these types of proceedings separate. But the original case and the transcript we included make very clear we made very separate arguments on the supervised release sentence we talked about, and I explicitly argued that those factors are not to be considered in a supervised release case. But the really important thing here to keep in mind is he got 46 months on a range of 37 to 46 for the new distribution of a little less than 3 ounces of heroin. And then he got 57 months, so a higher sentence on the revocation of supervised release from the original case. So this is the tail that's wagging the dog in this case. This is the bulk of his sentence here. Second, I need to, I think, read a quote. There's Tapia, and I came across this came up in another case.
Sure, it's a tail wagging the dog. I thought the judge, this is the second time he violated supervised release, or maybe, I don't know how many times it was. And the judge recognized that he just kept committing the crimes that for which he was originally sentenced, and gave him substantial sentences deliberately and made them consecutive on the supervised release as well as the original violation. And so that obviously the sentence on the original violation is subject to all the 3553A factors. And the court could clearly address those, couldn't it?
I think it is important to make sure that the just punishment, the retributive factors don't infect the supervised release revocation sentence. So I'm reading directly from Tapia versus United States. This is 564 US at page 326, is a Supreme Court case. For example, and this is analyzing the introductory sentence of 3583, so A, which lists some factors but not all. It says, for example, a court may not take account of retribution, the first purpose listed in 3553A2, when imposing a term of supervised release, see 3583C. So interpreting that exact phrase in 3583, the Supreme Court has held that a court may not take account of those omitted factors. And then this court in Crudup in 2006 said, again explicitly, that a district court is, quote, not authorized to consider those factors. So then you get to Webb a little bit later, and Webb cites all the cases that disagreed with Crudup and says, actually, when the district court mentions just punishment, that's not enough to render the sentence plainly unreasonable. But I think in order to be consistent with Tapia and Crudup, Webb has to be read really as a harmless error. If the district court mentions just punishment in the course of discussing these factors, but it's clear that that's not driving the boat here, the seriousness of the offense is not driving the boat, then it's sort of, it didn't affect the sentence length, and it's not plainly unreasonable under that super deferential standard. But when a district court lists 3 factors and 2 of them are forbidden as a reason to sustain the sentence, I think it's pretty clear that the district court is considering the seriousness of the revocation conduct and the seriousness of, or the need to promote respect for the law. It's the lack of respect for the law that the district court is punishing with this revocation sentence, which is a forbidden factor. Just briefly before I run out of
factor at this stage, it seems to me it's important to keep in mind the function that the court is performing. And when the court performs a revocation sentence and imposes a revocation, it's actually called a sanction some places, like in the guidelines, for revocation violation. It's not addressing the original conduct, and it's not based on certain factors relevant to the original sentence. It has to be focusing on the revocation conduct. And that's an attempt to regulate that. But now the court imposes a sentence of X months for the revocation sentence. And when that comes subject to review for reduction, it seems to me the court can still ask whether that was just, and not with respect to the original offense, but with respect to the revocation. I think the role of the court in reviewing its revocation sentence later would seem to allow some latitude in reconsidering or looking at its revocation sentence.
Well, so 3583, which governs revocations and also modification.
That's the imposition of a revocation sentence.
Okay.
I'm trying to bring to your attention my question about the imposition of a revocation sentence. Clearly, by the very nature of the proceeding, has considerations that are different than the initial imposition of a sentence for the underlying crime. But now we're in a process where we're reviewing a revocation sentence to reduce it. And the question is now, what can the court consider under 3553A in reducing that sentence? And I would think the criteria at that point, as applicable, are going to be different than the criteria when it imposed the sentence.
I would have to disagree. I think that gives no work to the phrase "to the extent they are applicable" in 3582.
Well, we're debating what's applicable.
Right.
I mean, it seems to me the court says my 57-month sentence or whatever it was here for the revocation was an appropriate sentence in view of the revocation conduct. And it can say that, and it can say, I deliberately did that, and it's because the revocation conduct was so serious, it can review that just as it would do the same thing with respect to the underlying sentence. But it's not imposing the sentence. In other words, imposing the sentence, you have to focus on what are you imposing it for. And on the revocation sentencing, you're focusing on just post-sentence conduct, a supervised release violation. And but on this proceeding, we're now looking at to reduce that sentence, the revocation sentence. And so now the question is, what can the court consider as a matter of discretion? And I would think the weight of the revocation sentence vis-a-vis the conduct for which it was imposed could be reconsidered to decide whether to reduce it.
Yeah, I see.
I mean, that's as relevant or as whatever words you want to use, as the statute says. And I think Judge Gregory raised the, I think, important question of, is this legal or factual? In the government's position, it's basically factual as applicable.
I see my time.
Yeah,
expired.
okay, if you have an answer, it's fine, but
Very briefly.
I'm just trying to uncover what may be some justifications for differing approaches at differing times during this whole process. This case is made complex because it combines an original sentence with a revocation sentence and a review of both.
Factually, I think there's no problem with the district court considering the conduct that led to the revocation. That's part of the history and characteristics of the defendant, and obviously, but the question is what goals are appropriate. So 35-3A is factored to set out the universe of facts that can be considered, the history and characteristics of the defendant, who they are, and then the nature and circumstances of the offense, what they did. And then separately, it sets out goals of the sentence, what it's supposed to accomplish with imposing it. And that's where it's more limited. So the factual matters are always going to be relevant in every case. There's nothing a district court can be prevented from considering as a matter of fact. It's what is the purpose that's going to be imposed that is more limited in a revocation context under 3583. So I thank you, Your Honors, for the opportunity.
Thank you, Mr. Camden. Also, Ms. Mashara, for your arguments. We can't come down and greet you, but know that we appreciate you being here and your and wish you well and stay safe. And we'll ask the clerk to recess the court until this afternoon.